Hi guys, thanks for tuning in to another episode of Nuggets News. Today we welcome a guest who is leading a class action against the companies, the tech giants that pushed the crypto ad ban of 2018. So welcome to the show, Andrew.
Thanks, Alex. It's nice to be here, virtually in Australia, and I'm in Israel at the moment, but I'll be in Australia next week.
Okay, cool. So, as well, some people new to the space won't know that back in 2018 or even earlier, when things were getting really heated in the crypto space, we had all the big tech giants come out and ban crypto ads in some form or another. And now a lot of people were sort of theorizing that Facebook would launch their own coin and that sort of thing. And it's kind of played out a little bit that way. So maybe do you want to tell your side of that story and how you got into this?
Yeah, sure. Look, my background is as a technology and competition lawyer, going right back to working for Telstra in the early 90s. And including doing a lot of competition law stuff for Telstra. I went on to be general counsel in Australia of various telecoms and tech companies. I took on cases against the ACCC that went all the way to the High Court and beat them. I've actually won two cases that have gone to the High Court of Australia. Done quite a lot of litigation work in the course of that, although I was primarily an in-house lawyer, but I've done a lot of litigation. Worked in the US for one of the biggest US law firms on the competition regulation of AT&T and access to their services. So my background's been in tech. I have a computer science degree, and I, learn about PGP encryption and things like that way back like 25 years ago. And then I, unfortunately, for my own financial circumstances, was moving to Israel in 2008 when the Satoshi white paper came out. So I was really busy with other things and didn't really come across Bitcoin and cryptocurrency in any serious way until about like 3 years ago. When I sort of discovered it, and it really connected in with what I'd already known about, encryption and internet liberty. And if you might probably not guess what JPB stands for, but it stands as the initials of someone very well known and famous in the internet freedom space, who passed away, John Perry Barlow. So I was followed him back, 25 years ago. So when I came across cryptocurrencies, it was like, okay, wow, this is what they were talking about 20 years ago when I was at, 25 years ago when I was at university and studying computer science. And so I quickly sort of got into it. I started mining, firstly on my regular computers, and then I progressively bought a lot of GPUs to mine Ethereum and Zcash and, the various coins that were GPU mineable. By the time of the, crypto ad ban, I think I'd invested maybe $30,000 or something in setting up mining, and, had, almost 40 GPUs running, making the place hot. But so, I got into this from the bottom up. I think, mining is the bottom up. And then I started getting into other aspects. Discovered, proof of stake blockchains like Steam, or delegated proof of stake. I started being quite involved on the Steam blockchain. I had always been looking to blog, to write. I write a lot of stuff, and it was like I could never motivate myself to write on someone else's platform, and running my own website that, I'd have to do a lot of marketing to people to look at also wasn't my cup of tea. So I became involved in the cryptocurrency industry on a range of different layers. And I also was using my legal skills and my technology background to advise, write, blog, all this sort of thing in the space. And then when Facebook announced their cryptocurrency ad ban on the 30th of January, 2018, I immediately, I'm a very experienced competition lawyer, and, you have antenna, you have 25 years of experience in this. And it was like, ding, 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 this is anti-competitive. There's a problem here. And I think I posted on LinkedIn within a few days that I thought this was a cartel. or at least that I thought it was anti-competitive. And so once I had a bit of time, I looked into it and looked into the law in Australia and found that actually there's a really very clear breach, quite simple to prove. We have all the evidence we need. And these is very, very serious matters. A cartel is not just a civil breach of the Competition and Consumer Act, it's a criminal one. And it was extraordinary to me that they had been so foolish as to not at least seek authorization from the ACCC for their ban. I can't imagine they ever would have got through such a draconian ban, but if they'd been able to prove the level of scams that they allege, which I think is also false, they might have been able to get something through. But they didn't apply. They just ignored Australian law. And having worked for American companies with offices in Australia, it's sort of not surprising. But Australian law is, you can sue in Australia, we can sue their parent companies in Australia, and we can, enforce around the world. So we've got a clear breach. We've got damages that are enormous. Now, the $500 billion figure, it sounds ridiculous. It sounds, how could it be? But it derives from the amount that the crypto markets dropped in the week after the ad ban. $300 billion drop in 53% in the week after Facebook announced its ad ban. Another 100 billion, 30% after Google announced, and almost 100 million, I think 23% or something, after Twitter announced. So the damages directly flowing in the week, the losses flowing directly after the ad ban were very large and very, in terms of the impact, very large impacts. Now, there are shareholder class actions that go on all the time in Australia. They're the bread and butter of litigation funders. A company does something wrong, the share price drops 15%. The litigation funding companies are out there circling like sharks. Well, not like sharks, I shouldn't say that, because they're protecting consumers, but they're out there bringing actions all the time. Now, this was a 5 times bigger drop. It wasn't just one market impact, it was actually 5 separate market impacts that we can prove. So we think we've got a strong case on damages. And then you've got the exchanges. And this is really important because the exchanges, the prices were high, the volumes were high, and then Facebook banned. The prices went down by more than half and the volumes dropped by like 75 to 90%. I calculated that based on the volumes in January and a 1% fee either side for the exchanges, they were losing $14 billion a month in revenue. And that went straight to the bottom line. So that's a loss of profit that can be claimed. And it went on, the ad ban's still in place. Volumes picked up late in 2018. But for, at least 9 to 10 months, you have, very substantial loss in volumes, loss of revenue, loss of profit. That's a classically provable legal claim.
So just to play devil's advocate, what's to stopping them saying that there were so many scams, ICOs, and then it's their platform, they can, try to protect their users or whatnot. And the other argument would be that cryptos had several 80 to 90% corrections, and it was just correcting from 1,000 up to 20,000. And there's no way that you can sort of pin them as the exact cause.
Well, in answer to the first question, it's actually irrelevant. It doesn't matter if they were Mother Teresa. It doesn't matter. Even if the entire industry was scammed, they're still in breach of the cartel provisions. But that is far from true. In fact, there's a lot of talk about scams, but I've actually done quite a lot of investigation into it, and it turns out there's actually very few scams. Compared to the size of the industry, and the value of them is also very small compared to the size of industry. And the crypto scams as a percentage of total scams is very, very small. Most of what's been called scams is either just scammers sticking the word Bitcoin into their traditional scam. Well, that's not a scam. That's not a crypto scam. That's an impersonation scam. People impersonate the Australian tax office. It doesn't mean the tax office is a scam. The second thing is a lot of people say, well, just because the SEC in America says this token is an unlicensed security, it makes it a scam. Well, that's not true either. Most of these aren't in America, and the SEC may well be wrong. It doesn't make it a scam. It may make it a breach of US securities law, but it doesn't make it a scam. And a lot of it's just trolling of, competitive projects. Everyone says everyone else is a scam. The real evidence, the evidence that's admissible in a court, is something like a report from the ACCC on scams. The 2018 report from the ACCC on scams shows a minuscule percentage of total scams in Australia relate to crypto in any way whatsoever. The vast majority of those were simply ransomware asking for payment in crypto, which just proves that crypto's good as money. Doesn't make the US dollar a scam because crypto, ransoms are paid in it, or because terrorists use it. And even the small percentage of other scams were just other sorts of investment scams with a crypto angle, but they weren't actually crypto projects. They weren't ICOs. No one had created the smart contracts and set this stuff up like as an ICO and then to defraud people. There's not a single case out of $500 million of scams, and I think numbers, hundreds of thousands of scams, not a single case documented by the ACCC. So, people can say they're scams all they like, but the reality is reports from the ACCC are credible, admissible. Someone saying someone else is a scam, or someone saying that someone else on Reddit said someone else was a scam, is called third-hand hearsay. It's not admissible in court, and it's total rubbish. So not scams. So, but the point is, in terms of the case, there just isn't a defence of consumer interest. There isn't defence of protection from scams. There's just no defence. The only defence they would have had is if they had sought authorization, and if they were genuine in their consumer protection thing, they would have sought authorization, and they would have made those arguments to the ACCC, but they didn't. So actually, it's a big smokescreen. So what really happened? I'll go on.
No, you're right. You finish off. I've got another question afterwards, but that's okay.
Yeah. So in terms of the legality of the case, proving the case, the scam stuff is just completely irrelevant. It doesn't matter at all. It won't be admissible. The court won't be interested in it. The court will be interested in the technical things. Did they have contracts between competitors that had clause that restricted supply? The ad ban clause restricted supply. There were contracts between competitors, and that's it. They're done. Yeah. And they gave effect to that cartel provision that restricted supply. So that's all we have to prove. So as I said, it's quite, for anyone in the crypto, anyone that understands it, it's actually quite a simple case to prove. And I'm looking forward to seeing what they say in their actually legally filed defence.
So what's the next step? I know Facebook have got deep pockets and plenty of lawyers. How is this being funded? Is this just on behalf of Australians, or are you going for all sorts of jurisdictions? How does that all work?
Yeah. So this is a class action that anyone around the world who held cryptocurrency can join. The reason we're able to do this is because because cartels are actually quite often international in character. Classic cartel case, fairly recently, was a cartel regarding Malaysian airline cargo from Malaysia to Australia. So, as long as you can get jurisdiction over the party that was in the cartel, anyone that suffers loss can claim. So we can get jurisdiction over Facebook Inc., Google LLC, their parent companies, their Irish companies, all of them do business in Australia, and we can prove that. Basically, their websites are, when you log on to Google, when you go search on Google, you're doing business with Google Inc. So we can sue them in Australia, not just the Australian subsidiaries, which are also quite substantial. We can sue them in Australia, and anyone that has suffered loss can join that suit. The way a class action works in Australia is that a single plaintiff appears for the whole group, and you define the group, and everyone's in unless they opt out. And people don't normally opt out, because who's going to sue Facebook on their own or give up the chance of getting some sort of compensation for their losses. So that's the way it works in Australia. In terms of funding, we are a litigation funding company. Now, people are familiar with the no-win, no-fee model from America, where lawyers say, okay, I'll act for you, no-win, no-fee, give me 30% of the damages if we win, otherwise you don't have to pay anything. That model, law firms can't do that in Australia currently, although there is discussion that they might be allowed to. But what is allowed is for a separate litigation funding company to arrange the action, fund the action, get people signed up who agree to that no-win, no-fee arrangement, contract with the law firm, and that's what we do. So we are doing that, and I mean, also, I've also done a lot of the legal work. I'm an very experienced lawyer in this space. In terms of we're raising funds to run this case from a whole range of areas, including, other litigation funders are potentially interested in this. People in the crypto industry that want to support it on an ideological basis, because this claim, obviously, it's got a significant commercial aspect, but it's got a strong ideological aspect as well. And also people on the libertarian, conservative side of things, and also perhaps on the left side of things that don't like all these privacy breaches. Basically, anyone that doesn't like Facebook and Google and the extraordinary power they have that is being abused. Ultimately, this case is about absolute power corrupting absolutely. It's about companies that have become too powerful and are abusing their power and have to be cut back down to size. And there are much discussion about how to do that. We have the mechanism to do that.
And how long do these cases typically take to play out?
Cases can take anything from 1 to 5 years. These sorts of cases, look, I base this on shareholder class actions in Australia, which is sort of the closest analogy. They tend to settle. In fact, 99% of them settle before even going to court. That probably may not happen in this case, and I'm not sure I even want it to happen. But the case, the way the case is held in stages, it's a class action. So the court first hears the common issues, which are the issues to do with the breach of the act. Determining there was a breach, and then they'll make a finding there, and then there'll be a pause. Damages won't be dealt with then. Then basically there'll be a pause, and then, obviously, if we're able to prove, as we think we can, that it was a breach, there'll be extraordinary pressure on Facebook and Google to settle, because if they proceed to a claim, proof of damages, firstly, they've lost the case, they have to pay our legal costs, and secondly, if the court was even to find, 20 to 40% responsibility for these market drops, it would put Facebook out of business. Facebook can't sustain more than a $200 billion claim, probably not even less, because, this is, so if they don't settle, it could go very, very badly for them. So I can't say how long it could take. They may well want to. They'll try to fight it all the way to the High Court. Been there, done that. This case, the High Court only hears cases where the law's not clear. The law's crystal clear here, and they breached it. So but I'm sure they'll appeal. It's too big an issue that it will go on for a while. But also they might decide to settle at any point from now or the next 5 years. They might decide to settle. But this is a relatively simple case. It's actually a lot simpler than a shareholder class action.
Well, interesting. I wonder what a world looks like without Facebook, Google, and Twitter. I'm not sure. Yeah, if it's going to happen, but geez, it's interesting, and I definitely want to get you on the channel today to share those thoughts, Andrew. So good luck with everything, and I'll link the description below for people to keep track of your case.
Great, thanks very much, Alex.
Thanks, guys.
Okay, bye.